Do you have the site on West V State?
Yes, we have the site on West V State. I believe it's there. I remember it when we
Yeah, send it to me. That's fine. Okay, we are. Leave it on my code. Okay. We're back on. Defendants present, represented by counsel. Took a look at this in the back. Here's what the court is going to allow. On the first issue, the court having gone back and done a little bit of research on this, we've got West v. State, which the court based its prior ruling on the self-serving nature of the statement. I had to get my brain right. I'm going to cite, I've got West v. State, 200 Georgia, 566. It's an old case, but it effectively would permit even a self-serving statement to come in under these circumstances generally. So I am going to permit in the first issue, so I haul back to the house. I haul into my bedroom to get my .357 Magnum. I am going to permit the defense then to get this statement in because again, we'll keep the Bruton issue there, don't know if this guy's armed because the other night the guy stuck his hands in down his pants. Again, the court's ruling was based largely on the self-serving nature and the thought that it really wasn't necessary to explain. Giving it full context and having read through it, now I understand what the defense is trying to do, and I'll go ahead and permit that. As to this male speaker that comes out of nowhere, this mysterious male speaker that I assume somebody at some point did figure out. But what I'm going to permit is starting on page 26, starting at line 22, it brings context to what the state wants to get in on line 27. The conversation is also, I think, in full context down to the end of line 3 on page 28. So the court's going to permit then expanding what the parties had agreed to is what I understand is going on. I'm not touching the rest of the transcript and all the decisions that were made. This is simply based on what the court has read here from page 26, line 22 to page 28, line 3 in order to give context to the statement the state intends to use. Does everybody have those page and lines?
We do, and I presume since the state's calling Officer Granberry, they'll have a moment to instruct him to change we to I. Otherwise,
Let's go ahead and do that. Let's make sure he understands. Because I understand that is the Bruton issue that I don't want to have to go through the process of seeing if there's a waiver on that one sentence. Okay. Does the state understand the court's ruling?
Yes, Judge.
Okay. We can go ahead and inform the witness then. Just changing the we to I on the page 25, I think it was.
Yes, Judge.
No, it's not 25. I'm sorry. Sorry, 21.
What was 21?
That's changing we to I.
Oh, okay.
Yes, I instructed him, he knows that, but I will ask an indulgence on leading in order to make sure we do not violate that Bruton situation.
I'm sorry, I didn't catch that.
I'm going to ask an indulgence on leading in order to make sure we don't violate any Bruton situation.
Yeah, I don't know what you mean, but we'll see.
I think I understand the context of the question. The court, again, the state needs to take witnesses on direct, but this is a the way this has been done, cutting up this transcript, I'm willing to give the state a little bit of leeway to get the witness to the points in the transcript that we need to get to that have been agreed to by the parties and which the court has now ruled upon. I think that's it. I'm not saying we get to lead the whole time, but in order to move this along and make it clear what we're doing. Okay. Okay. I understand we can now get to the witness. State ready to proceed?
Yes, Judge, the state is ready to proceed. However, we have two witnesses here. One who's a short witness, I believe. Of course, I say that. I know the danger I'm stepping into. And then we have Officer Brandon Berry, who I now believe will be probably a little longer, given it is 4:22. Would the court prefer I put up Brandon Berry, maybe going to 5:30, or would the court prefer that I put up Adam Jackson right now, who's much shorter?
So the state thinks the Brandon Berry direct is going to be an hour?
I've got 7 pages of questions, so yes, I think it may be.
That answers the question. No, let's do the short witness, and then it looks like we'll get to Brandon Berry tomorrow.
Thank you, Judge.
Do we know who that short witness is?
Yes, Adam Jackson.
Okay. Everybody ready to go on that?
So hit that note.
Let's give everybody a chance to adjust their notes. We're going to need the panel, though. Yeah. Okay, yeah, because we need to introduce the witness. Is that? Oh. Is Liddell calling him in? Is the state ready?
No, unfortunately, the state needs a moment to shift for a second.
Don't blow it up.
Captain, I'm not.
Judge, while they're waiting, I have another one of those. Every time I get downstairs, I think.
Thank you, Judge, for that indulgence. We're now good.
Okay, stay ready to proceed?
Yes, Judge, we are. We're calling. I'll wait till the jury's in.
Okay.
Thank you.
All rise for the jury.
welcome back. All right. Oh. Yeah, just wait for the state to call the witness. All right, we're ready to proceed with the evidence from the state.
Thank you, Judge. At this time, the state will call Officer Adam Jackson.
Sure, tell the truth, whole truth, and nothing but the truth.
Yes, sir.
Go ahead and have a seat.
All right, Officer Jackson, how are you?
I'm good.
Go ahead and state your full name and spell it for our court reporter.
My name is Adam Tyler Jackson, AdamTylerJackson.
All right, and how are you currently employed?
I am employed by the Glenn County Police Department in Brunswick, Georgia.
All right, and what are your current job duties and responsibilities with the Glenn County Police Department?
I'm a patrol officer, so my job duties include responding to service calls when people ask for a police officer, patrol, drive a marked patrol car.
And how long have you been with the Glenn County Police Department?
I started in March 19th, 2019.
Now, have you spent your entire career in law enforcement with Glenn County?
Yes, I have.
Right. And so, you've attended classes and training at the Georgia Peace Officers Standards and Training Council?
Yes, I have.
All right, so you're post-certified.
Yes, ma'am.
All right. And do you have to go through a police academy, or did you go through post?
Police Academy.
And have you always been in the patrol division with Glenn County?
Yes.
And what Baker are you in?
Currently, Baker 9.
All right. Back in February of 2020, what Baker were you in?
I believe it was in Baker 11 on the north end of the county.
Now, today you are dressed in a suit. When you are on patrol, how are you usually dressed?
In a standard police officer uniform with, at the time, there was green slacks and a tan uniform shirt, badge on the shirt, name tag.
And normally, when you're driving patrol, are you driving a marked police car?
Yes, big white police car with big police letters on the side, lights on the top.
All right. And you also wear a body cam as part of that.
Yes, I do.
So are you familiar with the Satilla Shores neighborhood here in Glenn County?
I am now.
You are now?
Yes, ma'am.
All right. And what county is Satilla Shores in?
In Glenn County.
Now, had you ever been called personally to any burglaries or entering autos within the Satilla Shores neighborhood in 2019 into January, February of 2020?
No.
So prior to February of 2020, did you know Mr. William Bryan?
No, ma'am.
And prior to February of 2020, did you know Travis McMichael?
No, ma'am.
Prior to 2020, did you know Greg McMichael?
No.
All right, so I'm going to draw your attention specifically to the afternoon, Sunday afternoon of February 23rd, 2020, around 1 in the afternoon. Where were you?
I was, again, patrolling the north end of the county towards Jessup, and Officer Minshew was responding to a suspicious call, and at some point on the radio he said, "Shots fired." So obviously myself and several other officers all start heading that direction. Want to assist him, make sure he's okay, figure out what's going on. So I started heading that direction, got to the Satilla Shores neighborhood. At the time, I was a fairly new officer, so I took on a role of assisting other more experienced officers with handling things at the scene. My supervisor arrived shortly after that, and he asked me to go speak to any residents, see if anybody witnessed anything or anything like that. That was generally what I was doing.
All right, so how long do you think it took you to get to Satilla Shores from where you were at the north end?
Probably 12 minutes, 15 maybe.
All right, so when you got there, were the fire trucks and EMS already there?
I don't recall if they were there or not.
All right. So in preparation for your testimony today, did I meet with you previously?
Yes.
All right. And did I have you look at your body cam video?
I think at the time we hadn't looked at it.
Okay. But have you looked at it since then?
No.
No, you have not seen your body cam video?
No.
Okay. Did I ask you to look at your body cam video and review it?
I'm not sure if we discussed that or not.
All right. So when you arrived at the scene, who was already there?
Officer Minshew was already there, and I believe that Officer Brandonberry, they either arrived the same time I did or just within a minute or two of me arriving there.
All right. And when you got there, you were in a patrol car.
Yes.
And what did you see as far as the scene itself?
I saw there was a body in the street, and I saw a truck over to the side of the road, and I saw Officer Minshew over where the truck was.
So what was the task that you were then assigned to do when you arrived on the scene at the corner of Holmes and Satilla Drive on February 23rd, 2020?
My supervisor, Sergeant Leska, he asked me to talk to people that lived in the area, see if there were any witnesses, see if anybody had cameras that maybe faced the street, anything like that. I talked to one gentleman named Diego Perez and asked him if he had any cameras on the exterior of his home. He said he did, and that he would see if he had any kind of camera footage. He returned to me a short time later with a thumb drive memory card, which he said had video footage on it.
All right, so let's go ahead and break that down. You're out at the scene and you're tasked with interviewing witnesses. Was this a witness you picked out or someone who you got directed to?
He approached the area. I talked to several residents, but he was the only one that had anything as far as having the video footage or anything like that. So he was the only one by name that I talked to and got his contact information and all of that.
And when you located him, who was he standing talking to?
I'm not aware of him talking to anybody else.
Okay. And he offered to provide you with a USB sort of jump drive?
Yes, he had a jump drive that he said had camera footage on it.
All right. And at any point in time, did he ask you permission to go over and talk to Travis McMichael? I
don't recall if he did or not. If he did, I'm sure I would have said to stay where he was at, just, treating it as a scene. So.
All right. And with regard to the USB drive, did you actually collect that later from Mr. Diego Perez?
Yes, I did.
All right. Now, you didn't review the footage on that jump drive?
No. In a situation like that, I knew that we were going to have investigators respond, so I went ahead and just held on to that till I could give it to them.
All right. And once you obtained that USB jump drive, handed over to the investigators, what then did you do at the scene?
At the scene, I helped, we put up crime scene tape, got a crime scene log, which is just a sheet of paper where we write down everybody that's been on the other side of the crime scene tape. Got some other officers needed water, bug spray, things like that.
All right. And did you write a brief report in conjunction with the homicide of Ahmaud Arbery?
Yes, I did.
And your body cam video, did you upload that to the system at the Glenn County Police Department?
Yes.
Okay, so I want to make sure. You haven't looked at your body cam video?
I have not reviewed it. No.
All right. Will you be able to review it overnight if I ask you to?
Yes, I can.
Okay. All right. One moment, Your Honor. If you're able to watch about 1 minute of that body cam footage, would you be able to recognize it and authenticate it as your body cam footage?
Yes.
Okay. Judge, I guess I apologize. I'm going to ask the jury to step out so we can authenticate this body cam footage.
We'll stick it to its authenticity.
So Mr. Goff has stipulated to its authenticity, and we have stipulation?
For Greg McMichael, we stipulate.
All right. At this time, the state will tender into evidence State's Exhibit 329.
No objection then from the defense.
No objection.
It's admitted.
All right. So I'm going to direct your attention to the screen right there. We're going to go ahead and look at about the first 55 seconds. All right?
Let me know what you need.
That's me.
That's your voice?
Yes, ma'am.
You
That's
recognize
me.
it?
Yep.
All right.
You get a witness statement from that guy who's on up to the left? Yeah. Hello, sir. Did you see any of what happened? You didn't see anything. You got video. You got video of it?
Probably have been running down here.
Okay. Can I get your name? You got your ID or anything like that?
And I can put it on USB.
Yeah, that'd be great.
So who's the man that we're seeing right here that you're talking to?
That is Diego Perez.
That is Diego Perez. And who is he standing next to? Do you know?
I don't know who that is.
Okay. So I'm going to also go ahead and show you what's been marked as 317. And 317 and 318. So take a look at 317 and see if you're able to go ahead and recognize that.
Okay.
And is that a fair and accurate depiction of what is right there?
Yes.
All right, this time the state would tender the evidence states 317. And go ahead and tell the jury. Oh,
No objection. No objection.
No objection.
good. Thank you. Go ahead and tell the jury what we're looking at there.
We're looking at a screenshot from my body camera footage of Mr. Perez standing near the scene.
All right. So just simply a screenshot of what we're seeing.
Yes.
And then when we look at State's Exhibit 318, right, take a look at 318. Are you able to recognize that as another screenshot from your body cam?
Yes, that looks like about where the video started when I first walked up.
All right. At this time, the state would tender to evidence states 318.
No objection. No objection.
No objection.
All right. So with regard to 318, you had kind of parked your patrol car down a ways, right? And had
Yes.
to walk up.
Yes.
And besides interviewing Diego Perez, you did not interview anyone else at the scene, right?
No.
Okay. How long did you stay at the scene after you turned off your body cam?
Not very long, since It was a busy day. Once my supervisor got there and we started getting other calls, he asked me to leave to go take care of some of the other business in the county.
Okay. That's after you had obtained the jump drive from Mr. Perez.
Yes.
All right. All right, so I got one last question for you. With regard to the body cam video, the dates and times, are you able to explain to the jury the dates and times and how the timestamp works on body cam video? In other words, this says 1825 on it, even though it has the date of February 23rd, 2020.
Okay. Yes.
Now, obviously, 1825 is not when this is taking place.
Objection. She's testifying now.
Hold on.
Leading question.
Just rephrase.
All right. What time was it that you were there?
I don't set that clock that's on the camera, so I'm not sure why it's showing that date and time.
Okay, that's fine. I didn't know if you were able to explain to the jury why it shows that particular time. If you're not, it's okay.
I'm not, no.
Okay. I will go ahead and pass the witness.
Afternoon, officer.
Good afternoon.
I'm Jason Sheffield. We haven't spoken yet about this case, have we?
No, sir.
Okay. Is it fair to say that you were there to lend a helping hand in whatever they wanted you to do? You had no specific role as you
Yes.
arrived.
Just to assist.
And you met with Diego Perez, who appeared to be eager to cooperate with you.
Yes, sir.
The taking of his license, that's just something that you do to try to document who the relevant witnesses might be.
It's just a little quicker than saying what's your name, what's your address, all that. It's all in one spot.
And it was your understanding that he had relevant information about what had been happening in the neighborhood. Is that correct?
Yes, sir.
Specifically, what had been happening in the neighborhood as it related to the particular incident that was unfolding in the street there at that
Yes.
time. I interrupted you.
Yes,
You
sir.
spoke too soon.
No, I'm just
Okay,
agreeing
yes.
with you. Yes, sir.
And so he went back to his home and he produced several videos for you on a thumb drive.
Yeah, he came back with a thumb drive and I didn't review it. So
Okay, so you're not aware of the contents. on
no,
the
sir,
thumb
I'm not.
drive. But it's, to your understanding, it is whatever the history is that's been going on in the neighborhood that may be relevant.
Yes, sir. This is a pretty standard practice. Businesses, people that have cameras in their homes, hey, do you have any video footage? And they'll, we just trust them that they're going to collect the footage that they have access to and provide that to us. And in this situation, knowing that we were going to have investigators respond, I had no reason to review it, so I didn't review that particular footage.
Fair enough. Thank you.
Yes, sir.
No questions.
No questions.
Nothing further from the state.
Thank you. We step in.
Yes, sir. Thank you.
And as I understand it, you are excused for the day, but subject to recall. Yes, sir. Thank you. All right, ladies and gentlemen, we are at a good stopping point for the day. So we're going to go ahead and break for the evening. I'd like to have you ready to get started again at 9 o'clock tomorrow morning. During the recess, again, do not discuss this case amongst yourselves or with anybody else. Don't let anybody discuss this case around you or in your presence of hearing. Don't go looking for any information about the case. Whatever information may be out there, again, if you pick up the news, don't pick up the news, don't pick up news feeds, social media, whatever may be there. I'm just going to ask you to step away from all of that. And again, if anybody does approach you about the case, please notify the court and we'll go ahead and see whether we need to address that. So with those instructions and all of the other instructions I've given you to this point, we will see you tomorrow morning at 9 o'clock. Thank you for your service here in the Superior Court of Glenn County. Have a good evening.
All rise for the jury.
Y'all be seated. All right. Usually if I'm making some rulings on the fly and additional information comes up during trial, I'll just go ahead and supplement the ruling in the record just so at some point in the future, if we have to look back at it, we can go ahead and do so, and we've got the additional sites out there. I did found a 11th Circuit case which addresses this issue of the rule of completeness under Federal Rule 106. That's going to be U.S. v. Range, 94 Fed 3rd 614. That's a 1996 case that at least updates what I gave to you by about 50 years, which may be helpful, which also cites to a 7th Circuit case, United States versus Haddad, 10 Fed 3rd 1252, which also I think is on point. So I just want to make sure all of that's in the record.
May I put another couple of cases on the record too that support the...
If you ever need to supplement the record with additional cases, I'm sure you'll find the opportunity to do that. We don't need to do it here because the court's already ruled. I'm telling you what I relied upon as opposed to what's out there. All right. Anything from the state before we recess?
Yes, Judge. During the break, Mr. Sheffield informed me that we had sent off the Travis McMichael transcript interview with Investigator Nohilly to defense counsel for Travis McMichael, and we received nothing back, but a kind of go ahead, it's good, is what I believed. We received no, this is a brutal violation. We received no, we're going to want this extra stuff in rule of completeness. So we were moving forward and have been moving forward, believing we were going to put up Investigator Nohilly without any issues with Travis McMichael's statement, and a lot of it comes in. I've just been informed that no, that's not the case, and that they have issues with rule of completeness. So having been down this road before, what I assume is going to happen is we're going to have Investigator Nohilly testify to all of the things that we told them we were going to have him testify to, and then they're going to get up here and they're going to ring the bell and say, well, isn't it true? He also said, and then we're going to have to be in the position of objecting that that's not part of rule of completeness, but the bell's already rung and the jury's already heard it, because my belief had been that they would give me what they believed to be rule of completeness so we could iron those issues out beforehand, because that was the direction of the court. And that is not what has happened. So we're now in a position, the state's in a position of having to bring this to your attention, that there was no meeting of the minds on the Travis McMichael statement, and that basically we're going to object at this point in time to any desire for any rule of completeness statement, simply because we have been placed in a position, an untenable position, to have not been informed as to what it was that they wanted in, and that was the order of the court, and that was what I believed your ruling to be, that we were supposed to provide them with this and they were supposed to get it back to us, and now we're going to have this ringing of the bell and this cross-examination where the defense is going to get up here and they're going to read the statement, and no matter if we object, the bell has been rung, and we're asking for a ruling on that at this time. Thank you, Your Honor.
Yes, Your Honor. So we did exactly as the court asked us to do. We looked at the Bruton issue very squarely for an extended period of time and went back and forth with the state on the Bruton issue and submitted to them in red ink and in highlights all the things that we needed to address about Bruton, and did so in good faith and arrived then at what we thought the state was going to be offering under Bruton that would not violate our confrontation rights. We told the state, however, that as for rule of completeness, we would wait and see what exactly they put in at trial, and before we then asked questions to complete the information, we would identify what we thought needed to be heard to complete. We would share it, show it to the court, and the court could make a ruling. So the rule of completeness is a separate issue from Bruton. Our Bruton fears and concerns were about confrontation. And I think we've done an excellent job working through that issue with the state. The rule of completeness, though, Judge, is one of those things that kind of happens during trial at times, depending on what the state wants to offer. It is not necessarily a pre-trial matter. It's something that can easily be brought to the court's attention and dealt with. If the court directs me to get into what we think would complete these statements, I'm happy to do so. It's very easy, but we did not undertake that with the state, and we made it clear to the state that we were not going to undertake that with them, that we were only working on Bruton. So for that reason, I think we're in compliance, and I don't think it's going to be too complicated for these issues to come up as they do. I will simply show the state, I will show the court can rule, and we can move on. I won't ring the bell in front of the jury.
Understanding we just spent 40 minutes dealing with only 2 of those issues.
Judge, the state has elected to present its case through the statements, through an indictment that indicts 3 people as conspirators. They chose to bring this case to court in this manner. Now they want to make their case a case that potentially violates these gentlemen's confrontation rights. And so in order to do that, they must tiptoe carefully through that. We have cooperated. We have tried to talk with them and share our thoughts with them, and have done so over several weeks and months to comply with that so that our clients' rights aren't violated as they try to make their case. But rule of completeness, as the court sees, is simply a way to complete the subject matter that the state has introduced. And so we don't think it's going to be that complicated. Now, if the court directs me, I'm happy to give you the entire statement by Officer Nohilly. I've broken it down into subject matter, page, and line. And when the state gets into a subject matter that we feel needs to be completed, I can bring it straight to the court's attention. But otherwise, I'm not sure what else the court would ask us to do. But I'm happy to do whatever the court wants us to do. But I don't think we violated any kind of pre-trial order or ruling.
Final word from the state.
No, that was not made clear to the state on any level whatsoever. It's Travis McMichael's statement, and neither Mr. Goff nor Mr. Gregory McMichael objected to any of it. However, it was not made clear that, oh, we're going to go ahead and do this thing where we don't tell you what the rule of completeness is so that we can discuss it in advance. There's been absolutely no discussion. I've not been told one single time, by the way, Ms. Dunikoski, on page 37, we think this extra stuff should come in. The Hogues did us that courtesy, Mr. Goff did us that courtesy, but we have no idea what page and what line this is going to come in to, and it appears we're going to be spending a whole lot of time, I think, arguing over it, because once Nohilly gets off the stand, we're going to be in a position of, okay, so on this page he said this, and then we want this in, and we want this in, and I'd put it in if I agreed to it in advance.
Well, I'm glad we stopped before 5 o'clock, because the first thing I want to do, which is the same thing I ask counsel to do anytime we're under an issue like this, let's get together and see really if there is an issue the court needs to address. And if there is, I'll go ahead and address it in context, and until I get a clear understanding of what's being objected to, there's not a lot the court can do other than vent and indicate that I will be very frustrated if we have to spend the entire day tomorrow on Nohilly's statement and back and forth about the rule of completeness. This strikes me as something that probably could have, should have been addressed well in advance of now. And my hope is that we have an opportunity over the next little bit to take a look at his statement and figure out where, if anywhere, there really is a dispute. I haven't gone through the statement. Told counsel when the Bruton issue came up to go ahead and work through the Bruton issues, and if I heard that there was a problem, to let me know. Apparently this has now been, sort of a slice of this has been taken out. This is the first that I'm aware of it, as is indicated by my ruling today on the record, on the fly, with regard to the rule of completeness. So, doing a little bit of tipping at windmills here, but hopefully by the time it gets back to me tomorrow, Nohilly's statement will have been reviewed, and I'll know exactly what I need to rule upon, if anything. So, nothing to rule on now.
Thank you, Judge.
Okay. Anything further then before we recess from the state? From Travis McMichael.
Yes, sir.
From Greg McMichael.
No, Your Honor.
From Mr. Bryan. All right. We'll see everybody at 9 o'clock tomorrow morning. Thank you.